Good morning, everyone. We're here for first appearance court. It's December 6th. I'm Judge Giuseppina Miranda. I'll be presiding over the matter. Do we have Mr. Romero at the main jail?
Good morning, Judge.
Good morning, Mr. Romero. How are you?
I'm doing well, thank you.
Good. Apparently, they're asking I take someone out of turn, Mr. Mack, Patrick Mack.
Oh, okay. I wasn't informed of that, so
someone from the jail called the courtroom and asked that we do that. So, as I indicated, I'm Judge Giuseppina Miranda. I'll be presiding over first appearances this morning. If I can please ask all the attorneys to state their names for the record, beginning with the representative from the state.
Eric Linder on behalf of the state, Your Honor.
Thank you.
Brian.
Counsel, your name for the record.
Sorry, Judge. Brian Reedy from the Public Defender's Office.
Thank you. Good morning, Mr. Reedy. And then finally, at the jail.
Hector, your name for the record.
I didn't hear you, Judge.
Your name for the record.
Your name for the record.
Oh, Hector Romero with the Public Defenders.
Thank you so much. We have out of turn Mr. Patrick Mack here. Sir, Mr. Mack, good morning. I have two charges here pending before you. Apparently, we had a capias for a misdemeanor case, which carries with it a $100 bond, and then there's been an add charge of an escape and or an attempted escape. I've had an opportunity to review the probable cause affidavit. I do find probable cause for both charges. We have to make a determination regarding Mr. Mack's second charge there. I'd like Mr. Linder to please give me Mr. Mack's background, and then I'll hear from Mr. Romero.
Yes, Your Honor, the state is going to be requesting a $10,000 bond on count 2. Plus, should Mr. Mack post his bond and be released, that he be supervised by pretrial release services with a GPS monitor. First, I have concerns about his future appearance in court, noting that he was being surrendered to the jail by his bondsman on a capias. He was just arrested October 13th of this year for a capias on the same case as count 1 and another traffic matter that he failed to appear on. Additionally, Mr. Mack was just released from Florida State Prison on June 29th of this year after he was convicted on 2 separate robberies in 2012. One was a robbery with a weapon, the other was a strong arm robbery. He violated probation, was sentenced to 5 years Florida State Prison. And I believe, Your Honor, I should have the paperwork attached. He has been qualified as a career offender by the Florida Department of Law Enforcement.
Okay. Mr. Romero, your position regarding Mr. Mack.
Judge, in speaking with Mr. Mack, unfortunately right now he's unemployed. He's currently looking for work, however. Right now he lives in Pompano Beach with his mother. His mother's helping him financially. His mother works at a local church in their daycare department, so obviously their financial resources are quite limited. The $10,000 plus pretrial plus GPS with the $100 bond on count 1 is something which the state has requested, is something maybe a little bit tad out of Mr. Mack's mother's financial resources. We'd ask you to consider reducing it from $10,000 to $5,000 with the other conditions in place, Judge, and we would ask you to waive the $5 per day cost associated with the GPS monitor.
I would consider reducing the overall bond, but I'm not going to consider waiving the $5 GPS. Mr. Mack, I don't know what happened here. It got from something very minor to something very major, unfortunately for you, but I'll go ahead and impose a $5,000 bond on count 2 as you requested, but I am going to take the state's recommendation that you be on the highest level for GPS monitoring and that you pay those court costs on a daily basis.
So we're going to put him on GPS only on the count 2, count 1?
Yes, on the count 2. Yes, please. All right, thank you. Good luck to you, sir. And then going back to the beginning of the docket, we have Kawanza Jones. Mr. Jones? North Broward, thank you. Mr. Jones at North Broward, please.
1 second, Your Honor, he's coming.
Thank you so much.
Good morning, ma'am.
Good morning, Mr. Jones. I have several charges here I need to go over with you. Unfortunately, one of your charges is a no bond hold, so there's not much I'm going to be able to do for you today. Apparently on charge number 5, the state of Georgia is requesting your presence, so you'll be held until you can ultimately go to Georgia. In the meantime, there's a count 1 of possession of cocaine, which carries with it a $1,000 bond. Number 2 is giving a false name to a law enforcement officer. 3 is resisting an officer without violence. And 4 appears to be a writ of arrest. I believe it's a child support matter. It carries with it a they want $242 from you on that one.
Yes, ma'am.
I do find probable cause at this time. I'm going to maintain the bonds as is, and you'll be brought to the extradition court regarding your hold from Georgia, okay?
Okay, what about no time served?
Hang on just a second. Yes, ma'am. Your findings have all 5 counts? Yes, ma'am. I'm sorry, what findings?
Because the docket only had 1 count, so I'm not sure if your findings are all.
Well, it's on my paperwork.
Okay.
Yes, it's on my paperwork. I'm sorry, sir, you were asking me about time served for something?
Yes, on 2 misdemeanor charges.
I don't think it's in Mr. Jones's best interest to resolve anything at this time, Judge. There's no guarantee as to how that might affect his other matters.
Okay.
Why is that, sir? That charge is old. That's in Georgia.
Oh, you're talking about the Georgia charge?
Yes, ma'am.
I don't have any jurisdiction to do anything on your Georgia charge, sir. I wish I could, but I don't.
Oh, that's what I thought he was talking about.
No. We weren't sure what it was that you were talking about. He thought you were talking about the new charges that you have.
Yeah, that's what I'm talking about. The time served on the 2 misdemeanor charges, ma'am.
The 2 misdemeanor charges out of Broward?
Yes.
I'm not inclined to do that, sir. I'm sorry. You're going to have to deal with all of these cases, okay?
All right.
All right. Good luck to you, sir. Thank you. All right. Next we have Eric Michaels. Where's Mr. Michaels?
Approaching Judge at Maine.
Thank you so much. All right, Mr. Michaels, not much I'm going to be able to help you with either this morning. You appear to have an out-of-state hold from Michigan. They're asking that you be held no bond until you can be brought to Michigan. So you'll be seeing the extradition judge on your Michigan charge, okay? I do find probable cause to hold you at this time. Good luck to you, sir. Then we have Nicole Cooper. Ms. Cooper?
North Broward.
Thank you. Ms. Cooper, good morning. I have a misdemeanor capias here for you. Appears to be a trespass.
She would like to resolve this if possible, Judge.
Okay. Mr. Linder, you want to let me know a little bit about Ms. Cooper's background, please? While I take a look at the probable cause affidavit on the original case.
Your Honor, I'm showing 2016 trespass, 04 resisting without violence, burglary of a dwelling, grand theft in 03.
She does have a place to stay, Judge. She can stay with her boyfriend, and she has been living there.
I'd just like to see the facts of the trespass before I plea it. Here it is. There's some sort of plaza that you were trespass warned from, ma'am?
Looks
At
like it was,
young, at the
Yes.
young, do you know where I'm talking about?
Yes, ma'am.
Okay, where do you think it was that you were trespassed from?
It was in Publix Plaza by in Hollywood.
Okay.
Young Circle.
All right, and I have, if I consider pleading you out to this matter here today, you understand that I'm also going to make it a condition that you not return to this facility. You've already been warned not to go there again. I'm hoping that hearing it from me will make you understand you're not permitted to go there again. Do you understand that?
Yes, ma'am.
Okay, will you please raise your right hand to be sworn? You solemnly swear a firm testimony you're about to give is the truth?
Yes.
All right, you can put your hand down. You have the assistance of a public defender here this morning. Are you satisfied with his services?
Yes, ma'am.
Is anyone threatening you or forcing you in any way to plead no contest here today?
No, ma'am.
You understand that you do have a right to have a trial, at which time the city there would have to prove that you had been trespassed from this area and that you were in violation of that warning. You understand that, ma'am?
Yes.
You're giving up your right to that trial, yes?
Yes.
And no one's forcing you or threatening you in any way to plead no contest here today?
No, ma'am.
All right, I'm going to go ahead at this time accept your no contest plea as freely and knowingly entered. I'm going to go ahead and withhold adjudication, take judicial notice of your time served, and require that you pay any court costs associated with this matter within a year. Good luck to you, ma'am.
Thank you.
Okay. All right. Next we have Kelly Gibbons.
North Broward.
North Broward. Thank you, Miss Gibbons. Good morning, ma'am. I have a traffic matter with a capious, and apparently it has a $1,500 bond on it.
Right. Can we work that out today, possibly?
I don't know. I'm curious as to why it would be such a high bond. Let me look at your
That's
record.
me too, because it should have
Oh,
been
hold
like
on, Kelly, don't say anything right now, okay?
Okay, ma'am, and your lawyer's asking, and I'm going to talk to him for a few moments, okay? So please try not to say anything. Let me see if I'm interested in resolving this matter here today. This hearing is being recorded. Anything you say will and can be used against you in the future. So please don't talk about your driving record or the facts of this case, okay?
Okay.
All right, thank you. All right, do I have Ms. Gibbons's record here?
Well, it's
Mr. Linder?
actually,
Yes, go ahead.
it's a traffic case number, but it's actually obstructing traffic, so panhandling, essentially.
Okay.
The reason I believe Judge Hurley set the bond where he did, Ms. Gibbons has a long history of this type of offense and failing to appear on this type of offense. She was actually here last week and resolved her case and was released on Friday for a trespass and a capious for the same type of offense.
Okay, understood. Would the, ma'am, it appears that you keep getting yourself in the same kind of trouble, and you were just in court recently, so I need to make sure that you understand that you can't be, participating in this type of behavior, and a night in jail doesn't seem to be able to do it for you, so if you're interested in resolving this matter, I am willing to do it. However, you're going to spend a few more nights in jail. Are you interested in resolving this case?
4 nights in jail?
I was thinking 5.
That's fine. I
Okay.
can do that, Your Honor.
All right. Please raise your right hand to be sworn. Do you solemnly swear
Yes.
affirm testimony you're about to give today is the truth?
Yes.
All right. You can lower your hand. You understand that you have a right to. You can lower your hand down, ma'am.
Okay.
All right. You understand that you have a right to have an attorney represent you at this and all hearings, and if you cannot afford it, an attorney, I can look into the possibility of appointing a lawyer to represent you. I can also need to indicate to you that you do have a right to have a trial in this matter, where the state would have to bring witnesses to prove the allegations.
Yes, I understand.
I understand, but let me just go through this real quick, ma'am. I'm trying my best to do it as quickly as possible. You're giving up your right to a trial today. You understand that?
Yes.
Is anyone forcing you or threatening you in any way to make you plead no contest here today?
No.
You understand that in order to plead no contest, I would be imposing a sentence of an adjudication, 5 days in the Broward County Jail as your sentence. Do you understand that?
Yes.
Are you pleading no contest?
No contest.
All right, I'm going to go ahead and accept your no contest plea as freely and voluntarily given. I'm going to go ahead at this time and adjudicate you guilty, sentence you to 5 days in the Broward County Jail, and require that you pay any court costs associated with this matter within a year of the matter, okay?
Okay.
All right, ma'am,
Okay.
good luck to you, and please stay out of the street, okay?
Okay, thank you.
It's dangerous for you, and it's dangerous for the public. Please take care,
Our Spanish interpreter is here, Judge.
okay? No, 5 days. Okay, do I have a Spanish interpreter, and do I have any attorneys that are here? Good morning, how are you? Sure, with the interpreter or without? No, let me go ahead and take care of you. Which counsel, state your name for the record and tell me which client you're here on.
George Odom, and I'm referring to page 13 of your docket, Alex Exantis.
Okay, Mr. Exantis.
Young man's at Maine, and he should be, well, he
Okay.
may be in the shoot now, but.
He's in Conti, Judge.
In Conte, okay.
Oh, they moved, okay, so
All right.
we're in front of.
Hang on, hold on just a second. Let me get your client first. Okay, yes, sir.
He's in courtroom 7750 this morning.
Oh, he is.
Judge Shear.
Okay, all right, but he still needs to be magistrated.
No, Judge, I'm sorry, I apologize. Yesterday, we held a bond hearing. Judge Shear deferred till today's ruling, so I'm headed over there now.
Oh, well, thank you so much for letting us know. So
No worries.
I'm assuming then I can just delete this from the docket?
I appreciate it.
All right, so Judge Shear is going to be doing his Just make sure that she does the actual bond hearing.
Do it there.
Okay.
I mean, I don't have an objection if the court just wants to do that for the record.
Alec, Exantis. Your Honor, what I was just speaking with Mr. Odom about is if he has an objection to the court making just a PC determination.
PC determination and put on here the bond to be set by Judge Shear?
Exactly.
All right, that's what I'll do then.
Thank you, Your Honor.
All right,
Y'all
thank
have a
you.
I'll find it for you. It's with
Okay,
the
so that
add-ons,
takes
if
care of
that
Mr.
helps.
Exantis. All right, then, going back to the regular docket, actually, if I could have the Spanish interpreter take the podium. Mr. Romero, do we know of anyone that may need the assistance of a Spanish interpreter?
I can inquire, Judge. No. There's one young lady here. There's two people on the docket. I believe they both would require a Romanian interpreter. One of them speaks a little bit of Spanish, so I was able to communicate with her in Spanish. But I figured since we're waiting on a Romanian interpreter, she would probably best understand Romanian.
Okay.
I've contacted the interpreter's office. They do have a Romanian interpreter available, but not until 1:30 this afternoon.
All right, so we'll reset the the two on the docket that need the Romanian.
Let me tell you who they are.
Please.
So we can go ahead and a little bit of Spanish.
The two Romanian speakers are on page 6. They're Ileana Ionita and Nicoleta Zamfir.
Okay, thank you. If the clerk can pull those, and if I come to them again, you'll let me know we're resetting them. If I could just ask the Spanish interpreter to please raise your right hand. Do you solemnly swear or affirm that you will translate from Spanish to English and English to Spanish to the best of your ability?
I do. Esteban Rojas.
Thank you so much, Mr. Rojas. If I could just ask you for the record to announce to the audience here if anyone in the jail needs the assistance of a Spanish interpreter in Spanish.
Habla el intérprete. ¿Alguna persona necesita interpretación al español?
To please take the podium.
Por favor, si alguien...
That main judge requires a Spanish interpreter.
Okay, all right. And do we know of anyone, you've been able to speak to everyone at the other jails and no one seems to need the services?
The only person I haven't spoken to is Timothy Kylon, but I don't believe he requires an interpreter.
Okay, all right, very good. Thank you, Mr.
And
Rojas.
there is-
Appreciate you being here today.
Yeah, that's it.
All right. Okay, going back to the docket again, we have Miss Olcaz.
North Broward.
Thank you. Ms. Olcaz, good morning. Sorry to keep you waiting. Unfortunately, there's not going to be very much I can do for you this morning. It appears that you have two misdemeanor capiouses, and the judge on those has requested your appearance in court. You do have a court hearing date tomorrow, as a matter of fact, with your assigned judge at 1:30 in the afternoon. You'll see your judge at that time to discuss your release, okay?
And for the record, Judge, Ms. Elkaz indicated to me she had a private attorney by the name of Andy Small. I was not able to find an Andy Small in the Florida Bar Directory.
I spoke to Mr. Smallman this morning. He couldn't make the hearing this morning, but he is aware of the hearing tomorrow afternoon, and he wanted me to let Ms. Alcaz know that he's going to contact her family.
Okay, all right. So, ma'am, your family's being contacted. Your attorney's aware of the circumstances, and you'll see your attorney tomorrow at 1:30 with the judge, okay? Good luck to you, ma'am. All right, next we have Ms. Freeman.
She's approaching, Judge. She's here at Maine.
Thank you. Switching to Maine. All right, good morning, ma'am. I have some paperwork here in front of me that indicates that you've been charged with a battery as well as a possession of cannabis. I've had reviewed the probable cause affidavit. I do find probable cause at this time. And it appears that the battery charge has a $1,000 bond on it. There's no charge on the possession of cannabis. Mr. Romero, anything on behalf of your client?
Judge, in speaking with Ms. Freeman, she's going to be requesting you to consider releasing her on pretrial release. The reason is basically she's not working. She's going through the process of applying through disability. She lives with her boyfriend, and right now he's unemployed and can't afford it. They've been living at the same place for over a year. My understanding, Judge, is she's been residing in our community for over 10 years. I'd ask you to consider releasing her on pretrial release, Judge.
And does she have a background?
Yes, Your Honor. And also, I don't, as far as living in South Florida for over 10 years, I see she was convicted in the state of Georgia 2016 for theft by receiving stolen property. She also had a failure to appear in that case. Convicted of disorderly conduct in the state of Georgia 2015. She was arrested in 2014 in the state of Georgia for failure to appear. Convicted of affray, fighting in the state of Georgia 2008.
All right, Mr. Linder, you've told me enough. Mr. Romero, I'm sorry, I'm not inclined to change that bond amount. It's going to remain at $1,000.
And Your Honor, we'd ask for an order of no victim contact.
And an order of no victim contact.
Then just two requests, Judge. Would you sign an order allowing us to photograph her injuries? And our second request is, would you sign a phone order allowing her access to retrieve her phone contacts from her phone so she could potentially call friends or family to post her bond?
No problem with both of those.
Thank you, Judge.
Ma'am, also, I don't know, ma'am, come back to the podium, please. I don't know if you know the particular people that were on the bus that allegedly started this whole situation for you. But irrespective of whether you know them or not, you're not to have any contact with a person by the name of Vanessa Prudent, either directly or indirectly. You're not allowed to try and reach her, call her, have any friends or family members try to reach out to her. Do you understand that, ma'am?
Yes, ma'am.
All right, and if you violate that condition of your pretrial release, you could end up going back to jail. Do you understand that?
Yes, ma'am.
All right, good luck to you, ma'am.
Thank you, Judge.
Next, we have Ms. Tassos.
North priority, Your Honor.
Thank you. Good morning, Ms. Tassos. I have multiple charges here pending before you. You do have a hearing scheduled with your assigned judge on Monday, this coming Monday on the 11th at 10 a.m. I've had an opportunity to review the probable cause affidavit. I do find probable cause. Your charges are as follows: standing in the road, failing to disobey a police officer, leaving a place of safety, pedestrian crossing, a pedestrian failure to cross in a crosswalk, and then you have a capias for a misdemeanor, and it appears that you failed to appear for that misdemeanor case.
Your Honor, Ms. Tassos has been living here in Florida for 28 years. She is currently on a list, has a place at the Salvation Army to go. They are putting her into the HAC program. She would like to resolve these matters if possible.
What's the state's position on resolving all of these?
Well, just to advise the court, Ms. Tassos, and I don't even know if that's her name, frankly, because I'm looking at the booking sheet, and there's just a ridiculous amount of aliases. She has 13 prior felony convictions, 27 prior misdemeanor convictions, a total of 117 unknown dispositions.
I'm sorry, ma'am, I'm not inclined to resolve this matter today. You can see your assigned judge on Monday, and if the judge that's assigned to your case is willing to resolve it, then you can go ahead and speak to them there. You only have there's only a few days between now and the time you see your assigned judge. Good luck to you, ma'am. All right, next we have Miss Holloway.
Your Honor, she's on her way from the unit.
Okay, I'll skip her. How much time you think?
She should be here within 5 minutes.
All right, I'll come back to you in a few moments.
Not less.
Okay, I'll come back to you in about 5. Thank you so much.
Thank you.
All right, next we have Miss Wright.
It's a medical reset.
Medical reset, Your Honor.
Thank you. This is reset from yesterday again. We'll try one more time tomorrow. Okay. Next we have Miss Shaw. Where's Miss Shaw?
Judge, she's here present at Maine. She is approaching.
Thank you so much. Good morning, Miss Shaw. I've had an opportunity to review the probable cause affidavit. I do find probable cause. It appears that you have 2 charges pending: failure to stop or remain in a car accident involving non-serious injury, and operating without a valid driver's license.
Judge, I had an issue with the probable cause in this case.
I'm happy to reconsider it.
It seems to indicate that the officer was investigating a hit and run, and there was an independent witness who approached and gave information about the driver that fled the scene. But there's no indication that the driver who fled the scene was Miss Shaw. There's no type of identification made. There's no show up.
You and I were both missing the second page.
Oh, we're missing the second page.
Okay.
I don't know if you have it, Judge.
So there's a total of 3 pages?
Yes.
Yes, there would be. And having looked at the third page now, which I did not have before, it would appear that there was an identification made.
Okay, may I see it, please? Oh, okay. No, I have this page, so that's why I found probable cause. Okay.
Okay, well,
All
now
right.
you know why I didn't.
I understand. Very good. Thank you so much. All right, so with that being said, we need to discuss, Mr. Romero, we need to discuss your client's background
Exactly, Judge.
and her ability.
I'll let the state, I guess, go first, Judge.
She has no criminal history.
She has no criminal history, Mr. Romero.
Judge, having said that, let me just give you a little background about her. Right now, she is working. She works at the Sawgrass Mall in Hollister.
And I don't mean to cut you off, but can you give me an amount first that she thinks she might? If there's no amount, tell me there's no amount. If there is an amount, tell me what that amount would be.
I believe her mom, as a caretaker, can maybe afford like around $100 bond. I was going to be requesting an ROR for the following reasons. She's actually a freshman. She goes to Florida Memorial University. She's studying
hang on,
medicine.
before you go any further, apparently her mother spoke to... Okay, so her mom's working on a bondsman already,
Right.
so...
He's in contact with her, only waiting for the court to set something.
They're only waiting for me to set something, so
They're ready to post the bond.
I don't have a problem with your $100 suggestion.
For how much?
$100?
Beautiful. Thank you,
Okay.
Judge.
Ma'am, you
Your
need
Honor,
to understand...
I'm sorry, if they're going, and only because this is a third-degree felony, if he's saying the mother has 100, I would ask for a $1,000 bond because and it would appear that they could satisfy going through a bondsman. It's only because if it was a regular leaving the scene and there weren't any injuries, I wouldn't be making this request. But because there were injuries, and it's like I said, a felony.
But she also doesn't have a record, and ma'am, I'm just going to warn you right now, it doesn't appear that you have a valid driver's license, so you've got no business driving to begin with until you have a valid driver's license. And if you have to make sure that you come back to court. I understand that you may have made a decision here to leave this scene, but you have to come back to court. If you don't, your mom's going to lose her money, and then you're going to be sitting in jail waiting the entire time while this case goes through the system. Do you understand that?
Yes, ma'am.
All right, good luck to you.
Thank you.
Sylvia Garcia.
North Broward, Judge.
Thank you.
She is a medical reset, Your Honor.
All right, thank you. Do you have Miss
Your Honor.
Holloway back yet?
Yes, she is here now.
Okay, I'll go back to her, and we have a medical reset on Miss Garcia.
Ms. Holloway's approaching.
Hello.
Hi, Miss Holloway. Just give me just a quick second. All right. So, Miss Holloway, I have a probable cause affidavit here indicating that there is a capias for your arrest with a $500 bond. It appears that you missed court, and the underlying charge here was that you gave a false name to a law enforcement officer. I do find probable cause at this time. We have a $500 bond. Mr. Reedy, can your client post that bond?
I don't believe so, Judge. She would maybe be interested in resolving the case. Would you be interested in that, Ms. Holloway, if possible?
Yeah, I want to resolve my case.
Okay. Okay. All right. Let's hold off on that. Ms. Garcia, she needs me to call that one. Okay. So, what is Ms. Holloway's background?
She had a strong-arm robbery last year. She violated probation, was sentenced to 180 days county jail.
I'm not inclined to resolve this matter. I'm going to go ahead and maintain the bond at $500. Good luck to you, ma'am. All right. The confinement status is asked that I just go back administratively to Ms. Garcia again. What were you indicating was a problem?
She's
Okay.
The case was issued November 2nd, 2017. However, her judge issued a ROR warrant November 6th. So we were asking if you both of those are to remain a no bond on count.
No, but the way I read it was that the ROR came first, and then she missed her first BOP hearing date.
The RR came second.
It came second?
It was after the capious. The capious was issued November 2nd, and the warrant came November 15th.
I think Judge Roth.
All right, we're gonna go ahead and, we're gonna save it to the end of the docket, because I have people I need to take care of, so let's.
Is that Ms. Sawyer, Judge?
That was Miss Garcia.
Oh, Ms. Garcia.
Yes.
I thought she
Okay.
was a medical reset.
She is, but confinement status believes that she's being held no bond by mistake, that she should be on RO.
Oh, okay,
So we want to go
okay.
ahead and take care of her this morning,
Okay.
irrespective of that.
We
So,
have Mrs. Sawyer waiting.
I'm sorry, who is this?
Mrs. Sawyer.
Okay, perfect, thank you. All right, moving on to Ms. Sawyer, and then I believe I have a private counsel in the audience here, so I'll take care of his case in a moment. So, Ms. Sawyer, good morning. We have a charge of grand theft auto that you're being held on right now. I've reviewed the affidavit. I do find probable cause, and there is a $1,000 bond pending at this time. Mr. Reedy?
Your Honor, Ms. Sawyer has been living in Florida for the last 10 years. She is a high school graduate. She has a couple of years of college. She has her own apartment and has had one since 2013. She has had 3 children, ages 11, 6, and 3. She's given me the number of her boyfriend, who I believe would hopefully be able to bond her out. If her prior criminal history isn't too bad, I was wondering if the court might consider pretrial release.
What's her history?
Your Honor, I'm showing she's been arrested in the state of Alaska twice for failing to appear in court. She had a DUI in Broward in 2013. I'm showing she was arrested in Orlando in 2013 for failure to appear. That was on another DUI.
All right, give it. Your bond's been posted already, ma'am. We're just gonna leave it at the $1,000, okay? Good luck to you.
Okay. Good luck, Stephanie.
All right. Counsel, are you ready on your case, or do you need a few moments? Just step up to the podium when you're ready to go, okay? You're welcome. All right, and moving on, the next person we have is Miss Onita?
This is one of our Romanian speaking.
Okay, so she's gonna be reset to this afternoon.
Yes, ma'am. And the next one as well, the co-defendant, Ms. Zamfir.
Okay, they're both resets. So we'll hold
The next one, Your Honor, is Ms. Anders. She's a medical reset.
medical reset, again.
Your
Okay.
Honor? I would just ask that
Yes.
the
Again.
court- I would just ask that the court, since she's been reset from, I believe, the 2nd, if the court can make a probable cause determination and then have her brought back for the purposes of setting bond when she's ready.
That's fine.
That's fine? Okay, very good then. I'll find probable cause and we'll reset the bond determination. All right, thank you. All right, next we have Scott Mayberry. Where's Mr. Mayberry? Which jail, please?
Maine, I believe.
He's at Maine, Judge.
Thank you, Mr. Merrill. Good morning, Mr. Mayberry. I have a warrant here, cases for your arrest on a misdemeanor charge with a
It's a
250.
municipal ordinance, Judge.
I'm sorry, what? Municipal ordinance. Okay, it's an ad charge, count 4.
Move back. Don't get that close.
What are the other bonds that he's being held on? I can't hear you. Mr. Romero, I know you're not on this case, but would you be kind enough to mute the mic for me for a moment?
Oh, okay, no problem.
Thank you. Mr. Mayberry, I'll hear from you in just a moment. I just need to be able to hear in the courtroom here.
Count 1 is $750 on a felony theft, $100 on a trespass. He's being held no bond on a court order theft.
Okay. And what was confinement status trying to tell me, that same information? Okay. All right, so Mr. Mayberry, it appears that regardless of what I do on this particular count, that you're being held and you're going to be seeing your assigned judge. I don't know if you're interested in resolving this count or not.
I would advise him not to, even though I don't represent him, but I think we do represent him on the other charges.
I believe you do, so that was my concern. Mr. Romero, if I could ask you to come back to the podium.
Here you go,
Mr. Romero, you represent him. You represent him on his other charges, and he's being held on some other charges. And Mr. Reedy's indicating that he doesn't believe that it's in Mr. Mayberry's best interest to resolve this matter today. So I think I'm just going to leave the matter at $250, and he can see his assigned judge and deal with potentially pleading out some of his charges. Okay.
Yes, Judge. Let me explain it to him. Do you know what city this is out of?
He's got a no bond hold on a felony petty theft and a $750 bond on a petty theft and a $100 bond on a trespassing.
But the open container is the city that he's asking about. Can anyone tell me quickly?
What was the question, Your Honor?
What city the open container is out of?
Oakland Park.
Oakland Park, okay.
I don't think Mr. McLaurin handles Oakland Park.
Well, again, the assigned judge will deal with it on the day. The assigned judge may, his assigned public defender may decide to plead this out on that day. I don't know, but I don't want to do it today, okay? Thank you. Timothy Roman.
Conti.
Thank you. All right. Mr. Roman, good morning, sir. I have an ad charge here for you. Apparently, you've already come through bond court on some other charges, and there's a misdemeanor capias that was issued for you with a $500 bond on the charge of inhaling harmful substance. I've reviewed the paperwork, and I do find probable cause to hold you on the capias. What are his other two charges?
He has a no bond hold on count 2, Judge.
All right, so, sir, you have a no bond hold on count 2, so there's really not much I can do for you on this. Everything will be wrapped together, and you'll see your assigned judge. But this is just an administrative matter to serve you with the capias that you had outstanding, okay?
So this will all be resolved in front of another judge, is what you're saying?
Yes, it will, sir. Because no matter what I do here today, you still have that no bond hold, okay?
Right, I realize that.
Okay, all right. Good luck to you, sir.
So just sit tight.
Yep, thank you. Okay, then we have Mr. Jean.
Mr. Jean is approaching. He's here at Main, Judge. He's proceeding. He declined the public defense. Obviously, he wants to represent himself, Judge.
All right, very good. Mr. Jean, good morning.
Good morning, Judge.
I just want to make sure that I go over a few things with you. Apparently, you do not want the assistance of the Public Defender's Office, which is your right, but I just do need to inform you that you do have a right to have an attorney represent you at this and all hearings. If you'd like to reset this matter so you could hire your own attorney, you can do so. Or if you want to represent yourself, you do have a right to do that as well. If you do represent yourself, however, I do need to warn you that this matter is being recorded. And so anything you say about the facts of the case or anything that's happened regarding the facts of this case could potentially be used against you in the future. So please don't talk about the actual facts. What I have to do today is to determine what your bond amounts are. I reviewed your paperwork, and let me tell you what I found. First, do you want to go forward without an attorney today?
Yes.
Okay. If at any time during our discussion you change your mind and you want to stop and either ask Mr. Romero to represent you or ask me to give you time to hire your own lawyer, please stop me, and I'm happy to stop. Right now, I have 4 charges that are pending before you. There's a driving while license suspended, your first offense, and then you have 3 separate misdemeanor capiases. One of them is, so the driving while license suspended carries a bond of $100. Then the first capias is unlawful sticker tag that has a $50 bond on it. Then we have failure to register vehicle. There's a $1,000 bond on that. Excuse me. Actually, what is that? Is the paperwork incorrect? I'm just noticing. I only have 1 capias attached to this. It says $1,000, and it says, oh, I'm sorry. I see what it is. It's broken down into 2. So you have 1 capias with 2 charges: failure to register for $500 and unlawful sticker tag for $500. So you have a total bond of $1,150. Can you post that bond, sir?
No, I've tried to call my someone to doing that for me.
Okay, do you have any money at all that you can post a bond with, or is it just a matter of trying to reach somebody?
No, I'm trying to reach someone.
Okay, if you can reach someone, can you afford these bonds?
Yeah, but I've tried to reach someone, but I have to access to my phone.
Okay, so if I do an order indicating that we need to give you access to your phone, you'll be able to post these bonds as is?
Yes.
Okay, all right, well, Mr. Reedy, if I can impose on you. We're gonna do an order today that will be sent to the jail that's gonna say that you are permitted to have access to your telephone so you can get phone numbers, okay?
Yes.
All right, good luck to you, sir.
Thank you.
All right, next we have Mr. Is it Mr. Spencer? Yes, Mr. Spencer. Let me take care of this one last one. And, Mr. Spencer is represented by Mr. Romero. That's not what I wanted him to do. Counsel, do you represent? I don't seem to be able to get a rhythm going this morning. I don't know why.
Sorry about that,
No,
Judge.
that's okay. So I had called Mr. Spencer up when defense counsel came to the podium. So are
Your
you?
Honor, I have no problem waiting if you want to address
Okay.
Mr. Spencer.
I'll go ahead and address Mr. Spencer, and then we'll take care of defense counsel, okay?
Thank you, Judge.
So, Mr. Spencer.
Yes, ma'am.
All right, here we are. We have 8 separate counts here that I have to go over with you. You have first charge of attaching registration license plate not assigned, failure to register a motor vehicle, operating a motor vehicle without with a license expired tag. Then we have no proof of insurance, and then there's 3 KPSs for misdemeanor charges. Each of those carries with them a $5,000 bond on count number 6, and that one is a violation of domestic violence injunction and an unlawful use of false name. And then the last one is operating without a valid driver's license, which is another $500. So currently you have a total bond amount of $10,600. Mr. Romero, and you've also been scheduled to see one of the 2 judges that you've been assigned to on Monday at 11 o'clock. Mr. Romero, anything on behalf of your client?
Judge, right now, Mr. Spencer has advised me he believes his mom's going to post his bond, and I try to get into the question, how much does he think? He thinks going through a bondsman, she can try and come up with the premium of $600. I know right now he's facing $10,600, so that's over what financially his mom can afford. I don't know if you could reduce it by $4,000, make it somewhere more in the neighborhood of the $600 premium that his mother can afford.
Mr. Romero, unfortunately, given the violation of domestic violence injunction and the false name situation, I'm unwilling to do that. I'm sorry.
Judge, the only other thing on count number 5, the driver presents a non-current proof of insurance. On that count alone, would you consider it's a $100 bond? Would you just consider an ROR in that case? So then he would post just the $10,500 on counts 6, 7, and 8. No,
only because of all of these traffic infractions. We all have to carry insurance. It's just one of the things that need to be done. So he's going to have to bond on that as well.
Yes, Judge.
Okay. All right, counsel, your client's name, please.
Morning, Your Honor. Kevin Miguel on behalf of Anthony DuPont, page 19 of Your Honor's docket.
Okay. Give me just a moment to find his paperwork. I don't have it in a page order, so I have to go through all.
He's a present judge. He's here at Maine.
Thank you.
There's your attorney, Mr. Hill.
Good morning, Mr. DuPont. Your attorney's present. Give me a moment to find your paperwork, please. Here we go. All right. Mr. DuPont, you have been charged with some pretty serious charges here. We have a touching or striking battery, count 1, carrying at $1,000 bond, exposing sexual organ in public, a burglary with an assault or battery, and then another exposure of sexual organs in public. I have to make a determination today, not only as to probable cause, but count 3 of the charges against you is a punishable by life felony, wherein I could be making a determination to have you held no bond. So I'm happy to hear from the attorneys regarding finding of proof evident presumption great, and I'll hear first from state.
Your Honor, the state is going to be seeking no bond hold on count 3, as it is a punishable by life offense under Isaza v. State, and this is just for first appearance purposes only. Your Honor, relying upon the allegations in both probable cause affidavits, including but not limited to Mr. DuPont's post-Miranda admissions, Your Honor, the reason I'm requesting, and he does not have a criminal history, but the reason I'm requesting a no bond, Your Honor, is, and I won't go into great detail, but based on these allegations, I do have a concern for the public, particularly women in the community. Additionally, Your Honor, I don't know at this point in time what other release conditions could ensure the safety, considering these allegations involve using delivery drivers to come to him. So even to say, even hypothetically, if I were to say I was okay with a bond and a GPS monitor where he would be at home, that doesn't necessarily mean that these allegations can't continue, since he could always call delivery places and seek drivers to come to him.
Thank you. Your response, counsel,
Your
regarding
Honor,
my finding a proof evident presumption great.
First, I'll address the state's concern, which is the ability to protect the community based on the allegations. The allegation is that he's using a Uber Eats application to essentially get these individuals to come to the house. What we were hoping, Your Honor, would consider is setting a monetary bond, placing the defendant on pretrial release with an ankle monitor, essentially on house arrest, and making it a condition of that pretrial release that he not be allowed to use any electronic devices, whether it be a cell phone, iPad, computer, whatever it may be. I believe that is sufficient to protect the community in this instance. It is a weird set of circumstances. I am not making a contest to the probable cause. However, I would like the court to know that he is a young individual, 19 years old. He's lived in Broward County his entire life. His entire family lives in Broward County. He was gainfully employed at a business in the community. No priors ever in his life, no passport. He's not a flight risk. His family is here. He has his girlfriend, mother, and grandmother. Those are the individuals that he would be staying with. They are able to watch him and make sure that he has no access to electronic devices. What we were hoping the court would consider doing is setting a monetary bond somewhere in the realm of $7,500 total or $25,000 total. That's about what the family can afford.
And I can appreciate your circumstances, and they're not falling on deaf ears, and you'll be able to make your argument again to the assigned judge in this matter. But at this juncture, I have had an opportunity to review all the affidavits, and I do find at this juncture, given the information that's been given to me, that there is proof evident presumption great that he has committed a first-degree felony punishable by life. Therefore, I'm going to go ahead at this time and hold him no bond. However, you can make application to the attorney assigned, the judge assigned to his case for a author hearing to make the same argument that you've made to me today regarding safety factors. But at this juncture, I believe that that issue is best left for the assigned judge. So I'm going to have him held no bond. But thank you for your presentation.
Thank you very much, Your Honor. Have a good morning.
Take care. All right. We have next on our docket Shane Hogue.
He's approaching, Judge. He declined the service of public defender.
Good morning, Mr. Hogue. I have a capias here, misdemeanor capias, for your operating without a valid driver's license. The bond has been scheduled at $500. You have a right to have an attorney represent you at this and all hearings. If you cannot afford an attorney, I could look into the possibility of appointing a lawyer to represent you. You have declined the services of the public defender's office, however. You do have a right to go forward on this case to represent yourself, or if you'd like to hire your own attorney, I'm happy to reset you to this afternoon or tomorrow if you want the assistance of an attorney. Please understand that anything you say during this hearing is being recorded, so if you say anything about the facts of the case or the facts about your driver's license, it could be used against you in the future. I first need to find out, do you want to go forward on your own, or do you want to try and hire your own attorney?
I'll go forward on my own.
All right, very good. If at any time during the hearing you wish to have the assistance of an attorney, please stop me. Right now, there's a $500 bond. I'm not going to be talking about anything other than your bond and whether to release you or not. Can you post a $500 bond?
I'm not sure if it's straight $500 or if it's 10% of it.
I believe most, and I can't give you legal advice, but I believe most bondsmen will, the least they'll accept is $100 as collateral, to collateralize, the bond, so I can't really tell you, what that amount's going to be. So if you think you can, get $500, $100, I believe a bondsman will post it for you.
Can I resolve it today? Is it okay for me to resolve it today, Judge?
I'd have to look at your driving record as well as the rest of your criminal history before I would make that determination, but I'm happy to consider it if you want me to.
Your Honor.
Okay.
Yes, I'm going to hear from the state first, sir, to see what their opinion would be. Yes, sir.
I certainly have no issue if the court wants to make an offer, but as an officer of the court, I just want to make the court aware I'm showing that Mr. Haig is on probation until 2021 for child abuse and battery.
All right, so, sir, the state attorney made it clear to me that you're currently on probation. What's going to end up happening if you plead this case out right now is it could affect your probation, and you could be violated on your probation. So I think it's best that we just leave the matters as is, and you post your $500 bond, and you may want to get yourself an attorney, okay?
Okay.
All right, good luck to you, sir. Finding probable cause at this time. He waived, he knowingly waived the assistance of counsel this morning. We have Trevor Walker.
If we could recall that, please, Judge.
Which, recall what?
Mr. Walker.
Oh,
He's up in Pompano.
okay.
They're getting him.
All right, thank you. All right. Yes, ma'am. Mr. Walker's family's posting the bond? Okay. The family's posting his bond. Okay.
Right.
All right. All right, so moving on from Mr. Walker, we're going to Mr. Gary Altman.
Mr. Altman's here, present, Judge Amain.
Thank you so much. Good morning, Mr. Altman. Okay, you have a $1,500 bond on what appears to be a warrant for panhandling.
It's a similar situation that we had with Ms. Givens earlier in the docket.
Okay. So apparently, Mr. Altman has a very lengthy history of this, and he currently has a bond of $1,500. Mr. Romero, is Mr. Altman inclined to resolve this?
He wants to resolve the case, Judge. He's homeless, so there's financially no way he can afford a post bond. So, Judge, he's asking Your Honor to consider resolving his case today.
The only way I would do that would be for several days in the county jail. The last lady I utilized 5 days. I would be sentencing him to 5 days without credit for time served on this one as well. If he's interested in resolving it, that would be my offer.
Let me talk to him, Judge.
Thank you.
Judge, he wishes to accept the court's offer.
All right, sir, will you please raise your right hand? Do you solemnly swear affirm testimony you're about to give today is the truth?
Yes.
All right, thank you. You can raise your right hand. Thank you. You have the assistance of an attorney here today. Are you satisfied with the services?
Yes.
He's indicating to me that you're willing to resolve your matter today. Is anyone forcing you or threatening you in any way to plead no contest here today?
No.
You understand that you do have a right to have a trial, at which time the state would have to bring witnesses to prove the allegations that you were doing this panhandling in the past, and you're giving up your right to a trial today. Do you understand that, sir?
Yes.
All right. Are you freely and voluntarily entering into a no contest plea at this time?
Yes.
All right. I'm going to go ahead at this time then and adjudicate you guilty of the underlying charge, sentence you to 5 days in the county jail without credit for time served, and require you to pay any court costs within a year. Good luck to you, sir. Next, we have Mr. Littlepage. Where's Mr. Littlepage? Which jail? Main jail? Thank you. Sir, good morning. I have a capious misdemeanor here with a $250 bond. It's a suspended driver's license, first offense. I've had an opportunity to review the affidavit. I do find probable cause at this time. You do have a hearing scheduled with your assigned judge on Monday the 11th at 2 p.m. Mr. Romero, anything on behalf of your client?
Mr. Littlepage wishes to ask Your Honor if you would consider resolving his case today.
anything on that with the state?
I'm pulling his driving record.
Okay. Sir, I would potentially consider it depending upon what your driving record and any other criminal background you have. If you'll give me a moment, I'll look at it and let you know whether I want to resolve it or not.
It looks like this may be a third within 5, Your Honor, resulting in a 5-year habitualization.
I don't know that it's such a good idea for you to resolve this matter, sir. The state attorney's letting me know that you have several suspensions on your record, and that if it's 3 within 5 years, you could be habitualized and lose your driver's license for 5 years. Can you make your bond, sir? I'm not inclined to resolve it today.
Yeah, no, there's just no possible way. I just paid my rent and stuff, and just put food in the fridge, and I do have to go to work. I'm supposed to be going to work this Sunday, and I'm supposed to be working today.
Okay, well, unfortunately, whatever work you do have, you need to get there without driving a car. Do we understand that?
No, I do that, ma'am.
Okay.
I'm just asking, is there any way I can get a promise to return to court? Because when I did miss court on that day, on October 30th, I did call the clerk's office. I realized it was a couple hours later, and then I just could not make it in. They couldn't reschedule it. It wasn't like I was trying to run from it. I came to court on the first day. It's not like I'm trying to run from this at all.
When you missed court, did you self-surrender, or did you have to wait for a warrant to take you into custody?
No,
You got picked up.
Me.
Okay.
Yes, but I did try calling rescheduling on that day.
Okay.
The problem is, Your Honor,
Let me hear from the state. Yes, sir.
I see that his license has been suspended on 5 different occasions for failing to appear in court.
On tickets, probably?
Yeah, for traffic matters, he's failed to appear, but I mean, I think considering that, a $250 bond's pretty reasonable.
Sir, the most I can do for you is drop it down to $50. Good luck to you.
Thank you.
These are...
We have Edward Christie next.
He's approaching, Judge.
All right, Mr. Christie, I do have an affidavit here in front of me charging you with criminal mischief. I've reviewed the probable cause affidavit. I do find probable cause. Your bond's been set at $100. I'm adding a condition to your bond that if you were to be released from custody, that you are not to return to the Speedway located at 5002 North Dixie Highway in Oakland Park. Given the circumstances, it appears that restitution may be required in this case, and then we do have a victim. I'm not inclined to change the bond amount, so I'm going to remain the bond at $100. Good luck to you, sir.
Judge, the only thing I'd ask you, he's homeless, so financially there's nothing he can afford. I understand there is probably restitution. There is a victim. However, I'm asking you to consider releasing him on standard pretrial, ordering him to report once a week, so therefore he can handle this case not here in custody, Judge.
What's his background, Mr. Linder?
Your Honor, he was arrested March 30th of this year for battery on a law enforcement officer, disorderly conduct, and threat to specified individuals. He received 364 days county jail. He was released Monday, November 27th. He was then arrested this past Sunday for possession of an open container. He pled that out and was released on Sunday. Just a very lengthy history, similar, not similar, but tied to this, but threats to specified individuals, disorderly conduct, theft, and aggravated assault.
All right, I've heard enough. Mr. Reedy, I'm sorry. Not Mr. Reedy, Mr. Romero, I'm sorry. I'm not willing to change the bond.
Thank you, Judge.
And I just saw that same lady, Mr. Reedy, that you had told to go to Judge Cohen. She just peeked her head in again. Can you see what, she's in the vestibule there. Can you see if she needs our assistance, please? Thank you. All right, Daniel, B-E-R-A-K-I. There he is.
Mr. Baraki is here present, Judge.
Thank you. Mr. Baraki, good morning. I have a capias here on a misdemeanor with a $1,000 bond. I do see that you apparently self-surrendered. Are you able to Post that $1,000 bond, sir?
Judge, Mr. Baraki informed me he has a bondsman that's going to post his bond, Judge.
Okay, very good. All right, thank you. All right, next we have Benjamin Gethers. Mr. Gethers, good morning. I have 3 charges here with you: resisting officer without violence, trespass, and loitering and prowling. I've reviewed the probable cause affidavit. I do find probable cause. It appears that you have a $100 bond right now. Is he able to post that bond?
Judge, he believes his mother will be able to post his bond. She works at the cleaners, but she doesn't get paid till Monday. So he's going to have to wait till Monday in order for his mother to post his bond. Considering, Judge, I believe from what he advised me, this is his first adult offense. Would you consider releasing him on pretrial or ROR?
I think he's lucky to have that $100 bond given his background. So he'll wait till Monday.
Yes, Judge.
Thank you. Timothy Kylo.
No problem.
Mr. Kylo, good morning. I have a capious misdemeanor with a $1,000 bond.
It's a trespass, Judge. I think Mr. Kylo might want to try and resolve it if possible.
Mr. Kylo, you're interested in resolving this matter? All right, the only way I will consider resolving this matter is after reviewing your criminal history, that I have your assurance that you will never return to this Publix again. I have your assurance, sir?
Yes, sir, ma'am.
Okay, Mr. Linder, his background, please.
Yes, Judge. As far as state priors, he pled out a couple trespasses October 2nd of this year, theft last year, failure to leave property last year, felony theft 2015, grand theft 2015, goes on from there. Judge.
Okay, so, sir, I'm willing to resolve your matter for an adjudication time served if you're willing to plead no contest here this morning.
Yes, ma'am.
All right, and in addition to the no contest plea and the adjudication and the time served, the condition of your being released is no return to that Publix. I understand things can be hard, but if you're asked to leave someplace, you just need to leave, okay?
Yes, ma'am.
All right, very good. Please raise your right hand. Do you solemnly swear a firm testimony you're about to give is the truth?
Yes, ma'am.
All right. You have the right to have a trial in this matter. You're giving up your right to a trial today. Is that correct? You can put your hand down. You're giving up your right to a trial today. You understand that, sir?
Yeah, I am.
Okay.
Sorry,
Okay, and no one's forcing you or threatening you in any way to plead no contest here today?
yes, ma'am.
All right, I'm going to go ahead at this time and accept your no contest plea as freely and voluntarily given. I'm adjudicating you guilty, sentencing you to time served, and you'll have a year to pay your court costs. Good luck to you, sir.
Yes, thank you. Your Honor, Mr. Walker has returned.
Mr. Walker's back. Okay, let's go to Mr. Walker.
He's coming up right now.
Thank you so much.
You're welcome, ma'am. Mr. Walker, over here, sir. Face the screen, please.
Mr. Walker, good morning. I've been told apparently that your family's posting your bond as we speak, or have posted it. They're posting your bond right now, sir, so you're going to be released here shortly. I'm going to maintain the bonds as is, find probable cause at this time. Your family's working with a bondsman right now, so you should be out later today, okay?
Okay, thank you.
All right, good luck to you, sir.
Thank you.
All right. Next, we have Mr. Rivero.
Conti?
Thank you. Mr. Rivero, good morning. You have a hearing date already scheduled with your judge on Monday at 8:30. This is count 5 of some multiple cases that we have pending before you today. And there's a felony capious for your arrest. that indicated it was for no bond. It's a possession of a firearm by a convicted felon.
He's entitled to a bond, Your Honor. I can provide you some information.
What are you suggesting as a bond?
You know, I was going to leave it in the court's discretion because, frankly, the other count attached to this case is robbery with a firearm where he has a no bond. There's a second case where he had a bond surrendered, possession of firearm by convicted felon, grand theft firearm, and possession of heroin, with a total bond $25,000 on the convicted felon and $1,000 bonds on the other two charges.
So, Mr. Rivero, it appears from what the state is telling me that this is just an administrative matter. No matter what I do today, you're going to be held no bond. So you were just, the capias just needed to be processed. So you're being processed right now. I'm finding probable cause, and I'm going to input a bond of $5,000 on this particular charge, okay? Good luck to you, sir.
Thanks.
Were you able to help her? Is she okay? Mr. Reedy? Yes. Okay. Okay.
You're next.
All right, next we have Anthony Smith. Thank you. All right. Mr. Smith, I have multiple charges here pending with you. Unfortunately, I'm not going to be able to help you too much because two of the matters that you have are parole violations, which I'm not permitted to do anything with. Those are you're being held no bond on those until you can deal with the Department of Corrections on that. You also have a burglary of an occupied structure, unarmed, grand theft, burglary of an unoccupied structure, unarmed, and grand theft. So you have 2 counts on each. These are add charges. You've already been through bonds court one time, and so we're just trying to clean up all your paperwork and get you bonds on everything. I've had an opportunity to review the paperwork. I do find probable cause as it relates to the burglary of a structure and the remaining charges. State have a recommendation as to count 3.
Again, Your Honor, on count 1, he's got a $5,000 bond on a burglary of a dwelling or structure with over $1,000 damage. Count 2 is a parole violation, so he's got a history of burglaries. Whatever bond the court deems appropriate, I'm fine with.
All right.
Ma'am.
Yes, sir. Please be
So,
careful in any questions that you ask me. Okay, just all right.
So, how many burglaries is this? 3 burglaries total?
I think it's 3 burglaries total. Yes, sir.
And 1 grand theft or 2 grand theft?
2 grand thefts.
And 1 parole violation.
2 parole violations.
Well, what
happens is you had 2 cases, so the parole violation
is a total of 3 now.
You have a total of 3 now because of the additional counts that you had. So it may be 1. It's technically 1 parole violation. It's broken down into charges though, but it's all the same parole.
It's really 1 violation.
Yes, sir.
Yes,
exactly. Okay. All right, so I'm going to go ahead and impose a bond of $5,000 on count 3. Count 4 will remain $1,000. No bond on count 5. $5,000 on count 6. $1,000 on count 7, and no bond on count 8. Good luck to you, sir.
Yes, ma'am.
All right. Next we have Mr. Kendrick Johnson. Is he at the main jail finally? Yes. Is Mr. Johnson there?
I've been advised Mr. Kendrick Johnson is a medical reset.
This is the gentleman we were trying to get here from yesterday.
From yesterday.
That makes perfect sense.
All right, so we will reset him until tomorrow.
Thank you, Judge.
Thank you. All right. And we have a large audience. Is everyone here just to view, to watch? Okay, very good. All right, next we have Roderick Edwards.
Mr. Edwards is here, President Judge at Maine. He declined the services of public defender. Come on up, Mr. Edwards.
All right, good morning, Mr. Edwards. I do have to let you know that you have a right to have an attorney represent you at this in all hearings. You've declined the services of the Public Defender's Office. You have a right to represent yourself. Or if you wish to hire your own private attorney, I'm happy to let you do that. I can set you back for later this afternoon or schedule you for a hearing tomorrow, whatever your preference is. Please understand, if you decide to represent yourself, this hearing is being recorded, So anything that you say can and will be used against you in the future, so I suggest that you not talk about the facts of this case. The only thing I have before me right now is making a determination as to whether there's probable cause, and also making a determination as to what your bond should be. You have 6 charges pending right now, so I need to first find out from you, do you want to represent yourself, or would you like to have time to hire a lawyer? Okay, and how much time do you think you're going to need? Do you think you can get somebody on the phone this afternoon? I'm happy to have you come back at 1:30 today, or I can roll you over to tomorrow. Okay, yes, sir.
Just to advise the court, Mr. Edwards is currently being represented by the Public Defender's Office in another case.
Okay, so I don't know, Mr. Romero, I don't know if you're aware of that. Mr. Reedy, apparently Mr. Edwards is being represented by your office in another case, but he's seeking to have an attorney represent him, or to have this rolled over to tomorrow to have a private attorney, or try to attempt to hire a private attorney, which is his right to do. Sir, though, if you do also have a right to have me review your charges within 24 hours of your arrest. So by rolling this over to tomorrow, you're waiving your right to a hearing within 24 hours. So I need to just make sure you understand all your rights and that you're waiving those rights. Yes, sir?
Yes, sir.
All right, so, sir, I'm going to go ahead and roll you over to tomorrow morning, give you a chance to hire an attorney. If you're unable to hire one, I mean, you can speak to Mr. Romero again about potentially at least having him represent you for this hearing, okay?
Yes.
All right, I'm going to, at this time, find that Mr. Edwards has been informed of his rights to a hearing within 24 hours, that he's waiving that right, and he's specifically requesting a reset so that he can hire his own attorney. Thank you, sir. I'll see you tomorrow morning. I'm here tomorrow as well.
Yeah.
Oh, Mr. John, good morning.
Hey, Judge, how are you?
I'm very good, thank you. Do you have a client on the docket
Yeah,
today?
if you don't mind, on page 22 is Elijah McFadden.
Happy to...
Thank you, Judge.
Happy to take him out of order. Mr. McFadden, we're at what jail? He's right there. Mr. McFadden, good morning. Your attorney, Mr. Jellin, is here. Counsel, you want to state your full name for the record,
Yeah,
please?
Bill Jellin, Yogi told me to come in today. Okay, Elijah?
Okay. All right, so, Mr. McFadden, you have 3 charges pending before you right now. I have a possession of PVP, neglect child without bodily harm, and a driving while license suspended. There's already a bond amount of $1,000 set on count 1. I need to make a determination as to count 2, and there's a $100 bond on count 3. Any argument as to probable cause, Mr. Jellin?
Well, the whole thing seems to start with a bolo, but there's no description in here of anything to do with the bolo, so we don't know if they even have the right vehicle.
That would go to the reason for the stop and not so much the probable cause for the arrest, correct?
Then, I agree, there are already a standard bond set. I would ask for an RR on the neglect charge. They're alleging that the substance was in the center council and that the juvenile, although, correct me if I'm wrong, I don't think it says how old the person is.
No, just reference a juvenile female.
Yeah, so again, I mean, these charges are obviously, I think the intent is dealing with very small children. If it was indeed a very small children who could be playing around or get into the center council, which I don't think anybody would have allowed anyway, there may be an argument that this is the charge, which I don't think will even be filed, but certainly if it's a teenager, something in the back with something concealed, not in the open, I don't think there's a probable cause for count 2.
Okay, so you're requesting ROR.
Yes.
In the event that I decline the ROR, can your client afford something on count 2?
I mean, can you put a $100 bond on there, Judge? I mean, he's already got a bond out on the other charge.
Okay.
Yes. I wouldn't have a problem with that. The only additional release condition I would ask for, Your Honor, is that there be a no contact order with, I'll just use the initials BT.
Well, we don't know if it's his child or what the deal is.
It states that it's his girlfriend's child.
We don't know if they live together, you know, that whole thing.
So under the circumstances, Your Honor, I believe it's still an appropriate request.
So they actually named the name of the juvenile that was in the car with him?
It's
Just
named
initials.
in the affidavit. The full name is given above the affidavit.
Mr. Romero, I'm sorry. Can I impose on you again to mute that microphone? I can't hear the state attorney.
I don't know the age.
Thank you.
Juvenile.
Or maybe I do, I'm sorry. I don't know.
Well, we'll look.
It also lists the different addresses. Just note.
We'll look. Okay. I'm sorry. You were saying, Mr. Linder, I didn't hear you.
Sorry, Your Honor. I was just going to ask for an order of no contact with the listed juvenile whose initials are BT. Her full name, and I just don't want to put it on the record, but it is.
But it's in the probable cause affidavit.
Yes, and just note.
Mine, I thought it.
You have you have an objection to the no contact order, Mr. John?
Again, my concern is I don't know if they live together, whose child it is, if he cares for the child, if it's going to cause having to move out of the house, all the standard concerns.
Do you need a moment to speak to your client to find out whether he has an objection to it or not? I don't want to have an argument over something he doesn't care about.
So they're going to set a low bond for you, but the problem is you won't be able to have any contact with that child. Is that going to be a problem?
No, that's not a problem.
All right, thank you. We're good.
It's not a problem. We're good. All right, so I'm going to do a no contact order with the alleged juvenile that was in the car. And we just won't say that name for the record, but he says he knows who it is and he doesn't have a problem with that. I'll go ahead and impose a $100 bond on count 2 for a total of $1,100. Anything else I can do before I let you go, Mr. John?
Nope, that's it. Thank you very much.
Thank you very much. Have a good day. Good
Thank
luck
you.
to you, sir.
Thank you. So a total of $1,200 total. Gotcha.
$1,200 total.
Thanks.
All right, next we have Calvin Stiles. All right, Mr. Dials, good morning. I'm not going to be able to do much for you this morning, sir. You have a no bond hold on a violation of probation on a felony case. You do have a hearing, though, scheduled with your assigned judge next Tuesday at 8:45. You can talk to your judge at that time regarding your violation, okay?
Yes, ma'am.
All right, take care, sir. Next we have Mr. Gonzalez.
Mr. Gonzalez, come on up, please.
Mr. Gonzalez, same scenario. Sorry, there's not much I'm going to be able to help you with today. I do have paperwork here showing that there's probable cause to hold you on a violation of probation. Your hearing date is on Monday, the 11th at 9 a.m. with your assigned judge. You can talk to your judge at that time regarding the violation, okay?
Thank you, ma'am.
Thank you. Good luck to you. Okay, I'm sounding like a broken record. We got Mr. Rodney Pillard, same scenario.
Mr. President, Judge?
Sir, good morning. I have probable cause to believe you should be held on a violation of probation for your felony case. You're being held no bond by your assigned judge. You see your assigned judge on Monday, the 11th at 8:30 in the morning. You can talk to them about your violation on that day, okay?
Thank you.
All right, good luck to you, sir. We have a violation of parole for Mr. Jeffrey Wagner.
Wagner is approaching, Judge.
Mr. Wagner, I've reviewed the paperwork here. I have find probable cause to hold you regarding a violation of your conditional release from prison, a violation of parole. They're asking that you be held to deal with the with the parole violation. They'll schedule a hearing with you or an administrative hearing with you with the Department of Corrections. You'll be sent to them shortly, okay? Good luck to you, sir. Another parole violation for Mr. Shaw.
He's approaching, Judge.
Mr. Shaw, good morning. I reviewed the paperwork here. I do find probable cause to have you held on a violation of your parole. The Department of Corrections is requesting that you be held until you can deal with your conditional, an allegation of violation of your conditional release. The Department of Corrections will deal with that with you through an administrative hearing. Good luck to you, sir. We have another parole violation. It's an interesting day. Mr. Rodney Jones.
No charge, Your Honor.
Thank you. Mr. Jones.
Mr. Jones is, I believe, hard of hearing.
Yeah, wasn't Mr. Jones with me before, or this is a different gentleman?
I think it's a different gentleman.
Mr. Jones, can you hear me all right?
Can you hear him?
Okay. Does he need a sign interpreter? Okay, he needs a sign interpreter? Can you jot on a piece of paper for me, Deputy, whether he needs a sign interpreter? Does he sign?
I'm not sure, to be honest with you.
Well, can you write on a piece of paper, ask him the question? Does he sign? Does he need an interpreter? Yes?
Yes.
Okay. We will get you we'll get you someone. We may have to reset him to this afternoon, but we'll let him know. And if you could show, I don't know if you have any paperwork there to let him know why he's being held on the parole violation, but we'll get a sign interpreter for him, okay? We'll make those arrangements.
Okay, ma'am.
All right, thank you. Thank you, Deputy. Moving on to Mr. Miller, we'll recall Mr. Jones once we can get a sign interpreter here. Where's Mr. Miller? Main jail? Mr. Miller, hello. Mr. Miller, good morning. Oh, okay. Mr. Miller, good morning. You do have a right to have an attorney represent you at this and all hearings. Right now, there's not much I can do for you. There is a violation of probation being lodged against you, reviewed the information, and I do find probable cause on the violation. You do have a hearing date before your judge on the Monday, the 11th at 8:30. Are you going to be hiring your own attorney?
Yeah, I already got an attorney on the case.
Okay, if you'll just let them know that your hearing's on Monday, the 11th at 8:30, okay? All right, take care, sir. Next, we have Marcus Hinnikin.
Mr. Hannikin's here present. Judge, I mean, Mr. Hannikin, come on up. Judge, he declined the service of public defender.
All right, good morning, sir. I have a charge here of possession of methamphetamine. You have a right to have an attorney represent you at this and all hearings. You've declined the services of the public defender. Are you planning on hiring your own attorney, or do you wish to represent yourself at this time?
Just myself.
All right, please understand that this hearing is being recorded. Anything that you say can and will be used against you in the future. My main concern here today is to determine whether there's probable cause and to determine what your bond amount should be. If at any time during our discussions you decide that you want the assistance of the public defender, please stop me, and I'm happy to have you have the assistance of an attorney. I've reviewed the probable cause affidavit. I do find that there's probable cause to believe that you may have been in possession of methamphetamine. Right now, your bond is at $1,000. Are you requesting that I lower it, or are you able to post that bond?
Lower, please.
Okay, and I need to know, in order to make a decision as to whether I should lower it or not, I'm going to be asking the state attorney about your background and whether you have any criminal record, and then I'm going to be asking you what you might be able to afford and or what your ties are to the community, how long you've lived in Broward County, whether you have a job, those types of things. So if I'll hear from Mr. Linder, does he have any record?
No, Judge.
Okay, so apparently you have no record. Do you work, sir?
No.
How long have you lived in Broward County?
Since 91.
Okay, and you have a permanent address here at this?
That's my wife's address, yes.
Your wife's address? You live there or no?
I'm staying with her.
You're staying with her? All right. And that's where your mail would go in the event that you, because this hearing, there's going to be future hearings where you'll have to come back to court. So your next notice of hearing will go to this mail. You make sure that if I do release you, that you will come back to court on the date that you're told to. Yes?
Yes, I will.
Okay.
Yes.
Let me take a look at this paperwork and let me see if I'm willing to release you. Well, sir, given that you have a permanent address and that you have no criminal record, I'll go ahead at this time and release you on your own recognizance. Please understand, however, that if you fail to appear for your court date, you will be ultimately arrested again, and that's not going to happen again if you miss your court date. Do you understand, sir?
Okay.
All right,
Yes,
good luck to you, sir.
Your Honor, on Mr. Jones, I'm advised we hopefully will have a sign interpreter for this afternoon.
Okay. All right, then moving on to Kelly St. Victor.
I've been advised she bonded, Judge?
He
bonded, I'm sorry.
No problem. Okay, so he bonded out. I'll find probable cause. Next we have Jerome Jackson.
Mr. Jackson's here present, Judge, I mean.
Good morning, Mr. Jackson. I have two charges here pending before you: possession of PVP and trespassing of an unoccupied structure. The possession charge carries a $1,000 bond. There's no monetary bond on the second charge. I do find probable cause at this time. Mr. Jackson, do you have the ability to post a bond?
Judge, and speaking Mr. Jackson, from what he informed me, he does not. Right now, he is basically supporting his father. He's asking you to consider releasing him on pretrial release. He lives with his father in Fort Lauderdale. He works for a company called Pioneer Roofing. He's been working for that company for 3 years, making about $15 an hour. He is a registered voter, from what he informs me, here in Broward County. He's been here his whole life, so I believe he has strong ties to the community. and I think he might be a good candidate for pretrial release, Judge.
Does he have any priors?
He has some old drug priors. I don't have an objection to pretrial.
I spoke with his mother this morning, who informed me that his sister has contacted the bond agent to post his bond.
Apparently, his bond's being posted.
Oh, so pretrial has advised Judge that your bond's going to be posted, so you'll be released today.
Your sister called and said that we called the mother, and the mother told us your sister's posting the bond. Now, if you want me to consider the pretrial release, if they're posting it, you may prefer the monetary bond, though.
It's up to you. I mean, if they're gonna if they told pretrial they're posting your bond today, then that's probably better than pretrial release.
Yeah, I'd say that.
Okay. All right. Well, I'll go ahead and leave it at the $1,000 then. Okay.
Thank you, Judge.
All right. If it's a problem, your lawyer will bring it back before me. All right.
Okay, we'll find out why.
All right.
But that's what they told you, so we're relying on that. Go for it.
Okay. Thank you. Okay. Next we have Willie Anton Falk. Mr. Falk, good morning. I have 4 charges here. There's really not much I'm going to be able to do for you. Apparently, you have 2 no bond holds on a violation of probation or community control. You also have a grand theft, which has a $1,000 bond, and a capias of $250. I don't see where he's got an upcoming court hearing date, though.
If it's on a Cape, well, he might not have. Oh, sorry, Judge. Because it's
Dade
out of
County?
Yeah.
Dade County. Okay. So, sir, you'll deal with your grand theft here with us, and then they'll transport you down to Miami for your probation violation. So you're going to be sitting with us for a little while you deal with your grand theft. Good luck to you, sir. Next we have Clinton Bannon. Here he is. All right.
Mr. Brandon is here present, Judge?
All right, sir, we have 2 charges for you. Illegal use of a credit card and petty theft. I've reviewed the probable cause affidavit. I do find probable cause. There's a $1,000 bond on count 1 and no charge on count 2. Mr. Romero, anything on behalf of your client?
Judge, Mr. Brandon advised me, he gave me his brother's phone number. He thinks his brother will be able to afford to post his bond, so I'll be contacting his brother today.
All right, very good, sir. I'll find probable cause at this time. Good luck to you. Next, we have Mike Blaze.
We would waive formal reading of the charges, Judge.
Thank you.
Sure, me. I don't know.
All right, good morning, sir. I've had an opportunity to review the probable cause affidavit. I do find probable cause at this time. Any condition of the release would also include a no contact order of the listed victim. I'm not going to announce her name on the record, but the paperwork, we'll do the paperwork necessary. In the meantime, I need to set a bond in this amount. May I please hear from the state regarding this young man's background?
Your Honor, he has no criminal history. Based on the allegations, I won't go into any details, obviously, but based on the allegations and the strength of the evidence against Mr. Blaze contained in the affidavit, the state would be requesting bonds in the amount of $5,000 per count in addition to the order that you just imposed.
Thank you. Mr. Romero, anything on behalf of your client and his ability to post a bond?
Judge, in speaking to Mr. Blaze, as you heard, he has no prior criminal record. He's been residing in our community for 18 years now. He's self-employed. He's a mover. Been doing that for about 1 year now. His average wage per week is about $250 per week. He lives with his mom. His mom is a receptionist. She's been working at the same place for about a year. He believes that she just gets paid minimum wage. He is a registered voter here in Broward County. He graduated from Coral Glades High School class of 2014. Judge, from what he believes, he doesn't think that he can afford the $5,000 bond, what the state has suggested on each count. We'd be asking you to consider setting a bond on $2,000 on each count for a total of $6,000. Hopefully, his mom can come up with the collateral plus the premium with the bondsman.
Given the fact that he has no that he has no priors, I'm going to go ahead and accept the recommendation from the public defender and institute a $2,000 bond on each count. And again, sir, you have no contact with this young lady, either directly or indirectly. Do you understand that, sir?
No contact.
No contact, you understand? Okay, all right, thank you. Good luck to you, sir.
Judge, can we recall Mr. Walker? He's the gentleman who's bonded out from Pompano. Because of his age, I'm willing to waive his presence for the purpose of magistrate court this morning in light of the fact that he's already bonding out. So if the court wants to fund...
Just do him? We just did
We
him.
did, but I think we had him on recall. Oh, did we just do him?
We did him.
Oh.
He came to the screen.
Oh, okay, okay.
We took care of him, and we told him that his family was posting his bond. No problem. Dominic Wainwright.
He's here present, Judge Amin.
Mr. Wainwright, not too much I can do for you today. Unfortunately, you have count 4 is a violation of probation. You're being held no bond. You do have a hearing date in front of your assigned judge on Tuesday, December 12th. You do have some new charges pending as well: possession of cocaine, driving while license suspended, and improper change of lanes on the traffic ticket. I've reviewed everything. I do find probable cause both on the new charges as well as the violation of probation. We'll maintain the $1,000 bond on the possession of cocaine, and you'll see your judge next week. Good luck to you, sir.
Good luck, sir.
All right, Mark Jackson.
Mr. Jackson is approaching here at me.
Mr. Jackson, good morning, sir. I've had an opportunity to review your paperwork. I have multiple charges I need to talk to you about. Charge 1 is a possession of morphine. Charge 2 is possession of alprazolam, also known as Xanax. Count 3 is a drug paraphernalia, possession or use. 4 is driving while license suspended, and then you have a ticket infraction of your tag being expired. I've reviewed the probable cause affidavit. I do find probable cause on all those charges. At this juncture, given the standard bonds that are in place, you would need to post $2,850 to be released from custody. Mr. Romero, anything on behalf of your client?
Judge, she's asking you to consider releasing him on pre-trial release. He is employed. He works for a company called Jones Awning. He's been working there now for about 3 months, making $15 an hour. He lives at a facility called Cornerstone Recovery. He's been there now for 1 year. I guess the fee associated with that is $175 per week that he's been paying with his job. Judge, at this time, he doesn't have the financial ability to post a monetary bond, so that's why he's requesting pretrial release, Judge.
Are you saying he was in a facility, he was in treatment when he was arrested?
He's at Cornerstone Recovery. That's where he's residing.
Okay. Does he have a background?
Yes, Judge. 2016 out of Jacksonville, drug paraphernalia. 2011 out of Jacksonville, DUI, property damage, child abuse. Fleeing or attempting to elude law enforcement in 1991 out of Jacksonville. Goes from there.
I'm more concerned with the more recent situation as well as the allegation that he may have had these substances in his possession while he was in a treatment facility. I'm not inclined to grant your request, Mr. Romero. I'm going to go ahead and leave the bonds as is.
Judge, our last request is would you sign a phone order so we can try and contact maybe some friends of his to see what they can do?
Yes, and actually I would be willing to reduce the $1,000 each to $500. I believe he does need a monetary bond, but I'll reduce those down. And maybe he may want to consider drug court. I don't know.
That might be an option, yes.
Yes, okay. All right, good luck to you, sir, and I'll sign that order so he can get his phone information. All right, Mr. Smith. Where's Mr. Smith?
Mr. Smith is here approaching Judge Amin. Mr. Smith?
Mr. Smith.
Page 22.
Mr. Smith, good morning. There's really not much I'm able to do for you today other than to let you know you have some violations of community control pending. And for some reason, it appears that you may have them in front of 2 separate judges. I'm not sure. But I do find probable cause to hold you on these violations. You have 2 hearings coming up. One on Monday with 1 judge at 9 o'clock, and then next week, the 18th, with a different judge at 8:30. Do we know, is there any way we can put these all together for him, or why is he on two separate dockets? Do we know? When you see the judge on Monday, your public defender should mention to them that you have this other case and this other hearing, so that maybe they can wrap it up in front of one judge. I don't know, but I'm going to hold you no bond at this time, okay, sir?
Judge, our only request is, would you enter an order allowing him to attend the SAP program while he's in custody and try and get
Absolutely.
treatment while he's in custody? Thank you,
Absolutely,
Judge.
no problem. Mr. Reedy will prepare that order for me.
Thank you.
That was on Mr. Smith? Okay. Bodie, Mr. Bodie?
Yes, here present.
Good morning, Mr. Bodie. I have two charges pending here. One's a ticket for disobeying, failing to yield at a stop sign, and then a driving while license suspended, third or subsequent offense. I reviewed the probable cause affidavit. I do find probable cause, and you currently have a bond amount of $750. Mr. Romero, anything on behalf of your client?
Yes, Judge. He's asking for you to consider releasing him on pre-trial. He's currently employed. He works at the Red Fox Diner. He just started making $12 an hour. Judge, he lives in Pompano Beach with a roommate. He's been residing at the same place for a year and a half. His monthly rent is about $700 per month. I know your Honor's concern is going to be for Mr. Bodie to not drive at all without a valid license. From what I found out, I believe the vehicle was towed. It's in a tow yard. He doesn't have the financial means to post the fees associated with that. The tag was confiscated, so he's not going to have any access to a vehicle.
Well, to his vehicle, but not. What about other people's vehicles?
Any vehicle. I just wanted to go ahead and share that information. He knows not to drive. He's going to be requesting, Judge, that you release him on pretrial release.
Does he have a background other than this traffic tickets and traffic infractions?
Just drug priors.
How far back?
From what I can tell, the most recent was 05.
Okay. All right. I'll go ahead and release you on pretrial release. They were unable to verify his address. Does he live with someone?
4890 Northeast 19th Terrace, Pompano.
Say the address.
4890 Northeast 19th Terrace, Pompano Beach, Florida.
Zip code?
Yeah, that's the one they have.
What?
That's the one they have.
Yeah.
Do you live with someone?
Yes.
Do you have a phone number of someone we can contact to verify your address?
My phone is at the house with every contact I have in it.
Can I release them to you all without verifying the address? I'll do that.
Absolutely can.
She's telling me I can.
Thank you.
All right.
Yeah, you're gonna have to go to.
She's telling.
As soon as you get out.
You'll have to go to. How quickly does he have to report? As soon as you get out, you have to report to pretrial because we can't verify your address. You have to report immediately. If you fail to report, then that's a violation of your pretrial release. Okay?
And you'll have no bond. So here's a map. As soon as you get released, it's probably going to be around, I'm assuming, 3 o'clock or something like that. You walk across the street and you go there. If you don't, you're going to have a no bond warrant issue. It's across the street. Look at the map. North, south, east, and west.
If you want
right across the street. See?
Okay.
Follow the arrow.
Thank you.
All right.
Okay, we've just got a few left. Just a couple more left, and then we'll be done for the day, for the morning. And if the students want to stay, I'm happy to chat with them. If you want to go to another courtroom, I totally understand. Okay, terrific. Thank you. All right, next we have Joseph Parisi.
Mr. Parisi, come on up, please. How you doing today, ma'am?
Very good, thank you, sir. Let's see, we have 2 charges pending for you. Unfortunately, this is a pretty serious allegation. At this time, I have a violation of probation, and we have a burglary with an assault or battery. I need to make a determination today as to whether you should be held no bond or not. Is the state requesting that I find proof evident presumption great?
Yes, Judge.
Okay. Mr. Reedy, anything on behalf of your client regarding my making a determination on proof evident presumption great?
If I could have a moment, maybe Mr. Romero can give us some background on Mr. Parisi while I look at the probable cause affidavit.
Very good. So, Mr. Romero, I'm considering making a finding of proof evident presumption grade. In the meantime, do you want to make an argument as relating to whether I should consider a bond? Your mic's off.
Sorry about that, Judge.
No problem.
Mr. Parisi is advising me that he financially cannot afford to post any sort of monetary bond. He's asking Your Honor to consider releasing him on pretrial release. If Your Honor.
Your Honor, may I?
Judge, he's actually can also afford to post a $1,000 bond on count 2, leaving the standard bond in place, which is, not the standard, I apologize, leaving the $1,000 bond in place on count 1, so for a total of $2,000.
Your Honor, I would note for the record, one of the allegations on his probation warrant, which Judge Bailey actually signed, I don't believe, there's nothing to indicate, because it's not one of the reasons listed as a violation, that he was aware of these charges. These were filed as a not in custody, so this is the first time he's appearing before a court on them. But I would note one of the allegations are for, one moment, he failed to report, and that was in
July.
No one's had at least no one with probation has contact with him since then. He's just being arrested now. I provided the court the case he's on probation for. He was originally placed on pretrial release. He was arrested for violating his pretrial release. The basis for that was he was put on a GPS monitor. He cut that off. He says to go to a funeral, never informed pretrial. They had no idea where he was. He already violated probation on the case he's on probation for once. And again, one of the reasons in that, in 2015, he failed to report and absconded. Your Honor, I'm asking for no bond because this is a PBL, but I also don't believe that there are any conditions that the court release conditions that the court can set him, Mr. Parisi, that would ensure his appearance in court.
As it relates to the proof evident presumption grade, Mr. Reedy?
Judge, this is not a typical burglary with a battery. It involves, I believe, reaching into a car and striking someone and removing them from the car. So it's not as though Mr. Parisi is charged with going into someone's home or burglarizing a house. It involves a vehicle, confrontation in a vehicle, and I guess that according to the probable cause affidavit, there's a history between the victim and Mr. Parisi and the co-defendant in the case. As far as probable cause is concerned, proof evident presumption grade is the highest legal standard that we have in the criminal justice system. It is higher than proof beyond and to the exclusion of every reasonable doubt. At this particular hearing, all the state has provided the court with in order to ask the court to make that determination is a probable cause affidavit. There's no warrant, there's no affidavit. The state has not filed, the state has not called any witnesses, the state has not introduced any physical evidence. Probable cause affidavits are designed to do one thing. That's to establish probable cause. Probable cause is one of the lowest standards we have in the criminal justice system, yet the state is asking the court to use that document to make a finding of proof at the highest level of our criminal justice system. I don't believe this probable cause affidavit is sufficient for that reason, and I would ask the court to set a bond for Mr. Parisi and not find proof evident and presumption great.
Thank you for your presentation. Twofold. First, your argument as it relates to the fact that this is not a residence. The statute doesn't provide for a distinction between a residence or a conveyance. It actually takes into consideration that someone can enter into a vehicle and strike or hurt someone and still be punishable, the charge still be punishable by life. Therefore, I decline to accept your first argument. Your second argument as it relates to the probable cause affidavit, though they're typically set forth sufficient information for probable cause, this affidavit sets forth more than just probable cause determination. It lays out all of the facts and circumstances of this case. The sworn testimony of what the witnesses would be testifying to as to the facts that caused this battery to occur, and everything contained within the probable cause affidavit lays out sufficient information for me to, at this time, to find that proof evident presumption is great. I'm going to go ahead and hold Mr. Parisi no bond. I understand that the warrant may have set $1,000 bond on this, but given the time and circumstances that have occurred and the lack of compliance that Mr. Parisi has shown in the past on the violation of probation, I'm going to go ahead and this time in sua sponte issue a no bond hold on the violation of probation as well. Thank you, gentlemen. Good luck to you all. All right, Mr. Reed. Mr. Reed is...
Here at Main, Judge.
He has an out-of-county hold. So, Mr. Reed, I'm not going to be able to help you much here. There's another county that's looking for your appearance, and that appears to be Martin County. So they're going to take you up to Martin County. In the meantime, you're driving while license suspended, third or subsequent offense. I'll maintain the $750 bond on that one. I do find probable cause to have you held on the no bond hold. Good luck to you, sir. Mr. Rattigan? R-A-T-T.
Kevin Rattigan is here approaching, Judge. Come on up, Mr. Rattigan.
Okay. I have to be frank with you, Mr. Romero. I'm considering increasing this bond from the $1,000. Sir, you're being charged with carrying a concealed firearm. I do find probable cause on that. And
Judge, I do have an argument on probable cause.
you? Go ahead.
It appears from the probable cause affidavit that the firearm was in plain view on the floorboard of the vehicle, not concealed at all. But the second firearm belongs to Mr. Short, based on his own admissions, and was in the glove compartment of the vehicle. So I think that the firearm that the officer intended to charge Mr. Rattigan with being in possession of is the one that's in plain view on the floorboard of the car.
I don't see where it says it's in plain view. It says he searched the driver's side floorboard.
I observed the black and color firearm laying in plain view on the floorboard of the vehicle by the defendant's right foot. And Mr. Short says he had a firearm in the glove compartment of the vehicle.
And, Your Honor, if I may, actually, and if you'd like, if you want to reset this, I can provide case law. Even then, the courts have found it has to be, this would, I believe, Your Honor, under the case law, this would still satisfy concealed firearm if we can reset it for 130.
I'm happy to reset it for 1:30. I'm going to reset him for this afternoon so I can review the case law. If you can get me the site sooner so I can read it over lunch.
Yes, Your Honor.
Okay, and I don't need the case. You just give me the site. That'd be fine.
Yes.
Okay. All right, so we're going to reset Mr. Rattigan for this afternoon, and then Mr. Short. What happens with Mr. Short going to be any different?
I think it is a different situation.
Okay. So let's talk about Mr. Short then.
Mr. Short, coming up, Judge.
All right, Mr. Short is charged with possession of cocaine and possession of cannabis. But if your argument's correct, then Mr. Short was the one that had the concealed firearm if he admitted to having the firearm in the glove box.
That would seem to be what the probable cause affidavit says, Judge.
So he's the one that should be charged with carrying a concealed firearm as well.
I would argue, yeah, I would argue they both, but in Your Honor, that determination will
be made at the filing stage. I understand that.
Yeah,
but in the meantime,
in
the meantime, I need to make a determination whether $1,000 is a sufficient bond for Mr. Short. Does he have any priors?
Does pretrial have anything?
The defendant has no prior record based on our investigation.
Okay.
I'll get you here.
Okay. Do you want me to consider reducing his bond then?
Judge, yeah, I believe you just heard he has no priors. He's asking Your Honor to consider releasing him on pre-trial release. Judge, he's working right now. He works for a teleperformance company. He's been employed there for 6 months, making approximately $12 an hour. He's a graduate of Olympic Heights High School, class of 2014. Unfortunately, right now, Judge, he's homeless. He's having a tough time, but going through that tough time, he's managed to hang on to this job for the last 6 months. He does have a mailing address, however, that would be of his family. They've had a falling out slowly but surely. They're reconciling. He's a registered voter in Palm Beach. His plan is actually to get back on his feet. He would like to save up and attend the Boca Institute to study massage therapy. Judge, right now, even though he doesn't have a home, I'd ask you to consider pretrial release. You can impose the conditions you want, and he'll abide by whatever conditions this court puts forward. He'll be there, in his own words.
I spoke to his mother this morning. Because of his drug use is the reason why he's no longer living with her.
Okay.
He moved out about 6 months ago.
I don't know if you can hear
You
that.
can hear the mic is on.
Pretrial release is indicating to me that they've spoken to his mother.
Yeah, she says because of his drug use.
And I'm assuming they probably confirmed that he's not living there. Like
He's
what
not
he
living
said.
there for the reasons of, she's not going to post a bond, and the reason he's not living there is his drug use. Honestly, Mr. Romero, I was considering increasing the bond, so I think that I'm doing you a favor by keeping it at $1,000. It's staying at $1,000. I'm finding probable cause. Good luck to you, sir. Okay, Anthony York.
Mr. York is approaching, Judge.
All right, Mr. York, I have a possession with intent to sell or deliver cannabis. I've reviewed the probable cause affidavit. I do find probable cause. Your bond is $1,000. Anything regarding Mr. York?
Yes, Judge, I have a probable cause argument on Mr. York's case.
I will reconsider the finding then.
As far as the element of the intent to deliver, this officer doesn't put any weights into his probable cause affidavit. It is extremely lacking in any kind of detail. It states that there were 5 small, clear plastic baggies containing a green leafy substance. It doesn't say how much of marijuana was in these particular bags, there's no indication that Mr. York was seen selling anything or any hand-to-hand transactions. The officer makes reference to a much larger plastic bag containing the same green leafy substance, but doesn't tell us how much is in this larger plastic bag either. There's insufficient evidence here to indicate that there is an intent to deliver. Possession of marijuana, based on the field testing positive, I would agree. But as far as the element of intent to deliver, that element is not established in this probable cause affidavit.
And I appreciate your argument. However, and the reason I found probable cause originally, and I'm reconsidering it with your argument, but I still find that it lacks what I'm thinking. And taking the larger bag in conjunction with the smaller 5 bags, there's sufficient information for probable cause purposes to determine that he may have been had the intent to sell or deliver. Additionally, his family has posted his bond, so he he can go ahead and be released because his family's posted his bond. Good luck to you, sir.
Thank you, Judge.
All right, then we have Mr. Black. Mr. Black, good morning. I have 3 charges here for you, one of them being a traffic matter, possession of cannabis, 20 grams or less, possession with the intent near a school or place of worship, and the failure to register a motor vehicle. You appear to have currently a $1,000 bond. Any argument regarding probable cause?
No, Judge. It looks well. Again, I'd argue that again. There's no possession with intent. He's not seen being involved in any type of hand-to-hand transaction. Apparently, he has some marijuana cookies or baked goods, which are individually wrapped, but there's no, I mean, aside from the fact there's a price on them, there's no indication.
You're missing the fact that on each individually wrapped cookie, there is a price tag on it.
He's an entrepreneur, Your Honor.
Okay,
Scale and
I
large.
think it's been a long morning and we're getting a little punchy. This is I know that it's saying in levity, but this is a serious matter. Sir, I find probable cause on the count 2 as well as count 1. There's a $1,000 bond there. Mr. Romero, anything on behalf of your client?
Judge, I believe you probably heard already. I believe this is his first arrest, but having said that, we're going to be asking you to sign a phone order allowing him access to his phone so he can contact his family, post his bond. He thinks his family can go ahead and afford to post the bond if he contacts them.
They're posting it right now.
Oh, so your family's posting it right now?
Okay.
Thank you, Judge.
Thank you. And then our last, from medical reset, do we have Mr. Lesprancis yet?
No, Your Honor, he's a medical reset yet again.
Your Honor, I'm going to be asking the court to proceed at this point in time. I believe this has been reset since Saturday. Your Honor, this is, and it's really a technical.
Can we hold it over to this afternoon?
Sure.
Thank you. And then I have a perfection, Mr. Means. Is Mr. Means still on? Thank you. This is our actual last one.
Yes, Your Honor.
This is trafficking in a Schedule 1B. What do we have here? I'm sorry, I didn't see this before the start of the...
It's a controlled substance, specifically fentanyl, Your Honor. The issue was the weight. The state has provided a supplement with handwritten by the arresting deputy with the additional information.
Okay, I'm reviewing the amendment. It indicates both substances are weighed at the district office. The marijuana weighed approximately 2 grams. The suspected fentanyl weighed just under 28 grams for specifically 27.5 grams. Anything else on probable cause?
No, Your Honor.
All right, I'm going to go ahead at this time and find probable cause based on the perfection. He's being held on the trafficking charge on a bond of $250,000. That bond will remain in place, and he'll see his assigned judge. Good luck to you, sir. All right, that concludes our docket for the morning. Thank you, everyone. We'll see you this afternoon after lunch.